51% of Canadians do not have a will. Let me say that again. More than half of all Canadians, including a significant number of people who are already retired, who have accumulated real assets over a lifetime, have made no legal arrangement for what happens to those assets when they are gone. And among those who do have a will, a large portion have one that is out of date, incomplete, or contains errors that will cost their families time, money, and in some cases, serious conflict. This is the conversation nobody wants to have. I understand that. But here is the thing about estate planning. It is not really about death. It is about what happens to the people you love after you are gone. It is about making sure that the money you spent a lifetime building goes where you intend. It is about making sure the people you love are not left to navigate a legal and financial maze at the worst possible moment in their lives. In this video, I am going to walk you through the 6 most costly estate planning mistakes Canadian seniors make. I am going to be specific about the legal and financial consequences of each one. And I am going to give you a clear checklist for what you actually need to have in place. My name is Grace Donovan. This is not a comfortable topic. Let us do it anyway. Mistake number 1, having no will at all. When you die without a valid will, you die what the law calls intestate. And when you die intestate, the provincial government decides how your assets are distributed. Not you, the government. Each province has its own intestacy rules. In most provinces, if you are married, your spouse gets a portion, but it is not always everything, especially if you have children from a previous relationship. If you are not married, but in a long-term common law relationship, your partner may receive nothing in some provinces, regardless of how many years you live together. The assets go through a process called probate, a court process that validates the distribution of your estate. This takes time, often months, sometimes over a year, and it costs money. Probate fees in Ontario, for example, are calculated as a percentage of the estate's value, which can be significant on a large estate. Beyond the financial cost, dying without a will hands your family a conflict they may never fully resolve. Who gets the family home? Who keeps the furniture? Who was supposed to get grandmother's ring? When there is no document that expresses your wishes, these questions become legal disputes. The fix is straightforward. Have a will drafted by a qualified estate lawyer, not an online template, not a do-it-yourself kit. A real lawyer who knows the law in your province, who asks the right questions, and who ensures the document is legally valid. A basic will typically costs between $300 and $800. For an estate of any real value, that is among the most valuable money you will ever spend. Mistake number 2, having a will that is out of date. Your will was written when your children were young, your ex-spouse was your spouse, your house was worth 1/3 of what it is now, and the grandchildren it mentions by name had not been born yet. It names an executor who passed away 8 years ago. An out-of-date will can be almost as problematic as no will at all. Life changes, marriages, divorces, deaths, births, major asset acquisitions or sales, all of these events should trigger a review of your will. As a rule of thumb, your will should be reviewed every 3 to 5 years and any time you experience a major life change. If the last time you looked at your will was over a decade ago, book an appointment with an estate lawyer this month. Mistake number 3, not having a power of attorney. A will only takes effect when you die. But what about if you are alive and no longer able to make decisions for yourself? In Canada, there are 2 types of power of attorney that every adult should have in place. The first is a power of attorney for property, sometimes called an enduring power of attorney, which gives a trusted person the legal authority to manage your finances, pay your bills, and handle your assets if you are unable to do so yourself. The second is a power of attorney for personal care, sometimes called a healthcare directive or living will, which gives someone the authority to make healthcare decisions on your behalf if you are incapacitated, and which expresses your wishes about end-of-life care. Without these documents, if something happens to you, a stroke, a serious accident, a dementia diagnosis, your family may have to go to court to obtain guardianship just to manage your affairs. That process is expensive, slow, and emotionally devastating when it is happening at the same time as a health crisis. Think carefully about who you designate for each role. The person handling your finances does not have to be the same person making healthcare decisions. Choose people who are trustworthy, organised, willing to take on the responsibility, and who will act in your interests rather than their own. Have both documents drafted by a qualified lawyer at the same time as your will. They are part of the same package. Mistake number 4. Beneficiary designation errors. This is the one that surprises people most because it can completely override your will. Many of your most significant assets, your RRSP, your RRIF, your TFSA, your life insurance, pass directly to a named beneficiary on the account or policy. They do not go through your will. They do not go through probate. They go directly to whoever is named on that account, regardless of what your will says. Which means that if your will says everything goes to your current spouse, but your RRSP still has your ex-spouse named as beneficiary from a marriage 20 years ago, your ex-spouse gets the RRSP. Your current spouse does not. The will cannot override it. This is not a hypothetical. It happens constantly. It generates enormous conflict and litigation. What you need to do: log into or contact every financial institution where you have registered accounts or life insurance. Ask for a copy of the current beneficiary designation. Review every single one. Make sure they reflect your actual current wishes and update them whenever your life circumstances change. One additional note: naming your estate as the beneficiary of your RRSP or RRIF is generally the worst option. It means those funds go through probate, incur fees, and potentially face higher tax consequences. Naming a spouse as beneficiary of a RRSP or RRIF allows a tax-deferred rollover, a significant benefit that disappears if the estate is named instead. Mistake number 5, not planning for the tax hit on your RRIF at death. This is one of the most financially significant estate planning issues and one of the least understood. In Canada, when you die with money in an RRSP or RRIF, the full remaining balance is considered income on your final tax return, unless it is left to a qualifying spouse, common law partner, or financially dependent child or grandchild. If it goes to your adult children, the CRA will treat it as if you earned the entire balance as income in your final year. Depending on the size of the RIF, the marginal tax rate can be 50% or higher. On a RIF worth $300,000, that could mean a tax bill of $150,000 or more payable from your estate before anything goes to your heirs. There are strategies to reduce this impact. Naming a spouse as beneficiary allows a tax-free rollover to their RRSP or RRIF. Systematic drawdown of the RRIF during your lifetime, especially in lower income years, reduces the balance and the final tax hit. Charitable donations made through the estate can generate significant donation credits that offset the final tax bill. An estate lawyer and a tax advisor working together can model this situation and identify the strategy that minimizes the tax impact for your specific estate. Mistake number 6, not talking to your family. This is not a legal mistake, but it may be the most damaging one of all. Families who are surprised by the contents of a will or who disagree with the decisions made often spend years in conflict and sometimes in litigation. Estates that should have been settled in months drag on for years. Legal fees eat up the inheritance. Relationships are permanently damaged. The antidote is a conversation. Not a comfortable one, but a real one. You do not need to share every detail of your will with your family, but telling your children who your executor is, where important documents are located, what your general intentions are, and why, especially if the distribution is not equal, goes a long way toward preventing the conflict that silence creates. If your will does not divide things equally among your children, because one received financial help during your lifetime, because one is a higher earner, because one has a disability and needs more. Explaining that reasoning while you are alive allows for a conversation that cannot happen after you are gone. Let me leave you with a practical checklist. These are the documents and actions that constitute a basic but complete estate plan for a Canadian senior. 1. A valid current will drafted by an estate lawyer in your province. 2. A power of attorney for property. 3. A power of attorney for personal care. 4. Up-to-date beneficiary designations on all RRSPs, RRIFs, TFSAs, and life insurance. 5. A secure location where all of these documents are stored, and at least 2 trusted people who know where that location is. 6. A review of all of the above every 3 to 5 years and after any major life change. If you have all 6 of these in place, your estate is in a fundamentally better position than the majority of Canadian seniors. If you are missing even one, that gap is worth closing now. Because estate planning is the one financial task where procrastination has a deadline, and you will not be there to fix the problem after it arrives. Drop your questions in the comments below. Estate planning is a topic with a lot of nuance and a lot of province-specific rules. If you have a situation you are trying to figure out, ask it below and I will do my best to point you in the right direction. And if you know someone who has been putting this off, a parent, a sibling, a close friend, please share this video with them. Helping someone put their estate in order is one of the most genuinely loving things you can do for them and for the family they will leave behind. I am Grace Donovan. I will see you in the next video.